My name is Ana Maria Bazan from the Bazan and Steinberg Law Firm. In this video, we will be addressing a memo from USCIS that became effective on September 11, 2018, concerning requests for additional evidence and notices for intent to deny. What this memo says is that it gives USCIS more discretion to deny petitions and applications and requests without issuing a request for additional evidence or a notice of intent to deny. If you're familiar with how USCIS worked before September 11, 2018, it was common for them to send a request for additional evidence. For instance, if you applied for an adjustment of status and you forgot to send your husband's naturalization certificate or passport, or you're applying for a waiver and you forgot to send enough evidence, or you didn't send enough evidence to substantiate hardship, then USCIS will send you a request for additional evidence. Or if they weren't satisfied, they could notify, we intend to deny your case, you should submit ABC. Now, after September 11, 2018, things are not going to be the same. USCIS won't be inclined to issue these requests for additional evidence anymore. It's not that they won't at all, but they want you to submit the full package right from the outset. So that if you go to an immigration preparer, you do it on your own, and you really don't have the knowledge and experience on how to do an application, it's most likely going to be denied. You should go to an experienced attorney that handles this daily, because they have a license and they have the knowledge and education and experience in these matters. Now, let me give an example of what cases could be denied. So if you apply, for instance, for an I-601A waiver and you don't submit sufficient evidence regarding the hardship that your U.S. citizen spouse or lawful permanent resident spouse is suffering, the case will be denied. Or if you file for adjustment of status, let's say your husband is a U.S. citizen and petitions for you, but you don't know that you need an I-864 affidavit of support, and you don't submit your taxes with it, and you don't submit the whole part of the application with that, again, your case will be denied. You will not get a request for additional evidence. What happens when your case is denied? You say to me, well, my case got denied. At least I tried to do it on my own. I didn't have to spend any money. But it's not so simple. After your case is denied, USCIS will most likely refer the case to immigration court. They will issue a notice to appear, obligating you to appear in front of an immigration judge to defend yourself, and you will be at risk of being deported. You have to understand that if your case is denied, not only do you lose the money that you submitted with immigration, but you're putting yourself at risk of being deported and spending a lot more money with an attorney that you didn't want to spend in the first place, because now if you're in removal, the case is going to be much more expensive, much more stressful, and it's going to take at least 3 to 4 years to process in immigration court. If you like this video, please watch my YouTube channel at Ana Maria Bazan Law Firm, and other videos that I'm gonna release on other USCIS policy memos and other updates on immigration law. Thank you for watching.